Hi, everyone. Thank you for sticking with us all the way. This is Plenary 3, the last panel of our conference. And I'm so excited to be moderating this one. It's called New Forms of Simulation with Tiffany Lee from the University of San Francisco School of Law, Madelyne Xiao from Princeton University, and Chau from Cornell Tech. So we will start with Tiffany.
Great, thank you, everyone. I hope you are enjoying your amazing bag lunch, and we're providing the entertainment. It's like dinner theater, but even better. So I'm here to talk about my new project. It's called Personalized Propaganda. And I've been working on these issues since at least 2017 when I was a fellow for the ISP, thinking about privacy, AI, and tech platforms. As you all know, because you're all working on these issues, these are difficult questions. And yesterday at dinner, a few of us engaged in a strong intellectual debate on two equally important questions. First, how many continents there are in the world? How many do you think there are? Yeah, see, there's a debate. Yeah. So that's important. But also the other question was whether or not global democracy is currently in decline. So equally important questions, equally hard to answer. But I mention that because the work we're doing is important. And all of you, especially those of you doing empirical research in the majority world, I think the work is critical. So my paper takes a bit of a high-level overview. I'm looking on a theoretical basis on the subject of propaganda in context of emerging technologies. I'm using a historical approach, and I evaluate how propaganda has changed in the advent of new tech, from the internet to artificial intelligence to what we call extended reality, which one of my colleagues here just spoke about on our last panel. From this analysis, my core finding is that each new technology has hastened a trend towards personalization of propaganda. So propaganda is now increasingly tailored to smaller and smaller segments of the population. And new technologies make it possible to target even individuals with disinformation. This personalization trend is important to recognize because it helps us figure out how the law should actually deal with these very critical problems. This particular paper started when I was trying to think through the results of Twitter versus Tamna and Gonzalez versus Google, Supreme Court cases decided last year, where the court was looking at whether or not technology platforms like Twitter and Google could potentially be liable even for an extremist attack due to potentially supporting and aiding and abetting these extremist actions. So this wasn't decided on necessarily ground related to personalization, but I'm going to get into why this was relevant later in this paper. Any first-year US law student is going to tell you that when there is a conflict between the First Amendment and literally any other value in American jurisprudence, very often the First Amendment is going to win out. This means that when American legislators try to fix the issues of disinformation, propaganda, bad content online, often what they run into is the First Amendment. So many of the solutions that they've tried haven't worked. And my argument here is that looking at the trend of personalization will point us in the direction of finding a better solution, which is going through privacy and data protection regulation to get at the heart of personalization, the means of personalization, as opposed to trying to get into speech and intermediary liability regulation that'll run into many issues. This is a work in progress. It's very early stage. I welcome all of your comments, and I'm excited to cite all of your papers from this conference. So really feel free to email me if you think your paper is relevant. This is America. We are very bold about self-promotion, so do reach out. Another recent case on this is in 2023, the Supreme Court granted certiorari to Murthy versus Missouri, a case in which multiple states sued members and agencies of the Biden administration, arguing that the government was impermissibly interfering with speech just by suggesting to platforms that maybe they ought to not allow unchecked COVID disinformation to run on the platforms. This is an issue in which we have actual lives in the balance. So disinformation can be deadly. Propaganda can have deadly consequences. I don't think I have to tell all of you here, you've done the research, right? You've seen what happens when we don't fix this propaganda problem. So this paper untangles the conflicting actions of US lawmakers in response to disinformation in the advent of the internet, AI, and virtual and augmented reality. By highlighting this trend of personalization, I hope to hone into an aspect of disinformation that I think is overlooked, and ideally propose novel legal solutions related to data protection and privacy regulation. I think this turn towards data protection laws can actually solve for the harms of the new world of disinformation and propaganda, this increasingly personalized world of propaganda. Unlike other proposals that will likely not pass constitutional muster and likely not pass the court of public scrutiny. So I'm going to start with talking a little bit about how the paper is structured. The paper proceeds in 5 parts. I examine the historical rise of the technological phenomenon of personalized propaganda, first through the pre-internet age, so modern propaganda, then through social media and internet propaganda, next through artificial intelligence, and finally through extended reality, so virtual and augmented reality. In terms of modern propaganda, the origins of propaganda are not clear. We've been doing this since we started being able to communicate to each other as a species. Efforts to sway enemy or rival groups through misinformation are nothing new. But in terms of the modern era, we are thinking about communications media like television, the newspapers, radio. I had a great conversation with Christina Spiesel yesterday, where I really clarified that what I'm doing here is thinking about every medium of propaganda and the way that each medium affects the way people take in information and understand information. And I think a lot of that has to deal with this personalized aspect. So we're going to get to this a little bit more, but let's get back to modern propaganda. In the modern pre-internet era, we have to think about a more limited media landscape. So only a few channels on your television, only a few radio stations you could receive, only a few newspapers on your local newsstand. Unless you were in a major metropolitan area, it was relatively difficult to find news outside of your region, outside of the major channels. This meant a more unitary field for media. This also meant that bad actors seeking to spread propaganda and disinformation had perhaps an easier time. They did not have to target specific audiences as much because they would know if they could get their message into one of the large media channels, it would be likely to reach a great segment of the population. Propaganda efforts did not have to be personalized due to the fewer channels of information. Further, personalization efforts would have been less fruitful. This is a pre-big data era. You could have done things like, say, target postcard mailers for political purposes to specific zip codes, but that's not quite the same as the algorithmic user profiles we're able to target people with today. So personalization may have been a factor, but today the technologies make it much stronger. Today we have an abundance of choice. The internet flattened the media landscape, making it so that we could access information from pretty much anywhere, anytime we want. It also meant that pretty much anyone could become a media player, right? Anyone can be a journalist in the age of social media and the internet. Anyone can be a media commentator. People turn now, especially young people, to social media sites like TikTok instead of traditional news sites like the New York Times, the Washington Post. What else happened with the advent of the internet? Well, we got the internet data ecosystem. Most websites and applications that are consumer-oriented operate on an advertising-based model, which in turn depends on the collection, use, and sale of consumer data. So this data-heavy environment means that there is a great resource for people who want to spread propaganda. The internet has made it faster and easier to spread propaganda, collapsing the media landscape, removing the power of this traditional top-down hierarchy of media companies' audiences. So bad actors now are able to have increasingly large operations and increasingly sophisticated operations, as a number of you have spoken about this conference. They use bots to automate creation and posting of content to attempt to sway opinion in online conversations. This also has offline effects as well. The internet has shifted the information sphere, and people expect news to come through in this personalized manner. We expect immediacy, personalization, and a level of autonomy in choosing what kinds of news sources we are able to access. So we have these new expectations of information, and we have this new world of data in which our data is now being used to potentially target propaganda back to us. The next stage I think is important to understand is the algorithmic stage. So thinking about the distinction between digital internet propaganda and algorithmic or computational propaganda, it's a little bit fuzzy, right? But I think we should look at this specific type of technology. The use of algorithmic propaganda or computational propaganda refers to propaganda produced using algorithmic methods in creation or dissemination. So pretty simple, right? We're thinking about automated means of creating propaganda, including, say, the generative AI applications that a number of you have spoken about at this conference. We're also talking about the deepfakes that, again, a number of you have spoken about as well. These are things that are happening on the ground. AI is being used to make it much easier to create propaganda, especially false propaganda. It's also much easier now to target people with algorithmic means by doing things like data mining, creating user profiles. So AI is creating a change in how we think of propaganda. The next technology I want to think about is immersive propaganda. So we had Michael Carey-Nicholas, who has since left, but he spoke about XR and propaganda. And I think this is a new way that we can think about propaganda, not just in terms of what it is, but in terms of what it might mean for personalization. I think that XR technology is going to exacerbate the harms of personalized propaganda. Virtual and augmented reality create somewhat immersive experiences. This might mean that it's harder to differentiate between authentic news and information sources and inauthentic sources. Due to the fact that you're already in a somewhat artificial environment, individuals may be less primed to understand the differences between authentic and inauthentic content. Additionally, the harms of such content might exacerbate. People might have a stronger emotional effect seeing different forms of propaganda in a virtual environment due to the differences of the medium itself. So the creation and dissemination of propaganda, again, will have greater effect due to the personalization available through the XR technologies. Now, many of our legal cases on propaganda, at least in the modern era with the internet and AI, courts have not completely understood what these media are doing. So we have a few cases in which the courts don't really understand what AI actually is. So in the Twitter and Google cases, for example, the court sort of glosses over the use of algorithms as if the companies have very little say in what the algorithm does, when in fact, we in this room know that the companies have designed and implemented the algorithms and are doing what they want with the specific recommendation systems and content moderation systems they create. This is not a failure that is unique to the United States. I think everyone everywhere has examples when the court misunderstands technology. But in most of our cases, we're trying to fix this problem in the form of speech regulation. We're trying to figure out how the government can regulate different types of speech, different types of content online. This is always going to run into a First Amendment issue. And again, the United States, that's a really hard bar to pass. In contrast, if we were to use data protection regulation to try to get at the personalization of the propaganda, this is a way to perhaps ameliorate some of the harms, to mitigate some of the harms of personalized propaganda by focusing on the actual techniques, focusing on the technologies that are inherent in the new world of propaganda. Focusing on data protection could also help in the court of public scrutiny. So not just strict scrutiny, but also public scrutiny. People don't like it when they hear the government is trying to regulate information, especially in the United States. The Biden administration tried to create a disinformation governance board a few years ago that was immediately met with backlash, despite the fact that multiple agencies within the US government at that time and today still continue to regulate and deal with policy issues related to disinformation. Naming anything a disinformation organization, governance board, agency, or law is going to have pretty bad effects on the public. In contrast, a privacy and data protection regulation is more practicable. People generally like the idea of privacy. It's something that could pass and could have actual effect. It could protect people's rights, and it could be something that companies are able to deal with on a consistent basis, in a perhaps easier way than waiting for the government to tell them what content is good or bad. So in general, I argue that looking at this historical lens on propaganda, looking at how each medium has changed propaganda, shows us that the trend towards personalization is something that we shouldn't ignore. And that instead, we should be looking at data protection and privacy regulation to fix the ills of personalized propaganda, something that affects all of us in the US and in the world. Thank you.
Okay. Want me to help? Yeah. Okay, so let me. So okay. So it is, okay, we'll have to deal with that.
Good. Am I audible? Great, thank you. Okay. All right. So, thanks for your time and attention. I am excited to present some continuing work, some ongoing work with my advisor, Jonathan Mayer, at Princeton University Center for Information Technology Policy. Oh, I'm Madelyne. I'm a third-year computer science PhD student. So this talk is going to bring a sort of information security perspective to the content moderation question. As a matter of personal credentials, I guess I was a fact checker at a long form, at a print media outlet before starting grad school. So this topic feels very near and very dear. And I think, while that setting was long form checking, I think those lessons are in many ways transferable as well to social media content moderation. All right, so without further delay, so the work itself, the paper that I'm presenting on was actually an SOK, or in InfoSec conference parlance, a systematization of knowledge, which is an active engagement with a subdiscipline in the field. In this particular case, it was automated detection of misinformation. So we surveyed 270 published works from a cross-disciplinary corpus of security, computational linguistics, and NLP AI work. And all these papers specifically described ML-powered approaches to the detection of misinformation, but also influence operations, or IOs. And we analyzed these works along a number of axes, but the ones I'll address most in greatest depth today concerns soundness of method design and ecological validity of evaluation. So if you have, you've taken the steps to develop XYZ classifier, in the evaluation cases, do those evaluation settings actually reflect real deployment settings? Is maybe the long definition. And then in the paper as well, we replicate and extend results from a subset, I think actually just 3 papers from the whole corpus that are representative of the state of the art for the field. And I don't expect you to be able to see the x-axis on this graph, but just know that there was an observable surge in both citations and just raw preprints and publication counts post 2016 for reasons that I think are apparent to this room. Right. So I won't spend too much time on some of the technical takeaways from the actual survey. I'll provide a brief overview of some of those findings. I'll spend more time on context and motivation, and also some proposed solutions to the problems we identify, possible next directions for research. I think all of these things are probably familiar to folks in this room. In recent times, there's been a push for increased moderation of content online, both from government, both from the top down, as represented by the blocks on the left, and some other more grassroots or bottom-up approaches as well. If anyone is still on X, formerly known as Twitter, you've probably seen community notes, which are, community user-driven annotations, which are then voted on by users at large. Sort of less well publicized is Facebook/Meta's third-party fact-checking program, which we'll discuss later in this presentation. But then also on the left, you have sort of attempts on the part of both the government and the platform itself to moderate from the top down. But my interest in this came from my work as, a human fact checker, someone who spent lots of time not so much litigating matters of true and false, but managing source relationships, wrangling the talent, speaking to writers and editors, and as members of plenary speakers have already said in previous sessions, so much of the substance of misinformation and disinformation, what have you, is actually, so much of that substance is not actually information per se. So much of it actually is, suggestion, implication, insinuation, opinion. So how actually do we classify these things in the literature? So our sort of first go at this was we systematize the literature along multiple axes, but we'll address only one of these for the sake of this presentation. So we did have to define units of detection, which for the sake of the paper, we split into 5 categories broadly. This is like the smallest atomic unit of detection that these classifiers are trying to label as true or false. So we have sort of at the far end claims, and at the other end websites as sort of blocks of things you could label as like, yes, true, verifiable, no, false, possibly misinformative. Today, I'm going to discuss the second of these on the slide, which is the methodological evaluation. So starting at the point of targeting, defining your target. So what exactly am I trying to understand? Is it misinformation, or is it like, like credibility? And then ending with evaluation, like, is what I've developed actually useful? Is it a great experimental method, or is it actually something I could deploy? So attention to the second, keeping in mind the first. This is a very simplified version of the methods development process for a classifier in this setting, but in NLP AI in general, for folks who've spent any time in this space, starting with data collection, proceeding to feature selection. And depending on whether or not your method is supervised or unsupervised, this could be a process that the developer explicitly undertakes. Like, I'm choosing to examine sentiment, lexical, stock, genre as possible feature parameters. And then, proceeding to training and evaluation, which is generally an iterative process. So after training, taking stock of performance and tweaking parameters and weights as needed. And then ideally, at the end of this entire process, you get a model which one hopes performs passively well on a test data set that the model has never seen before. That is the ideal scenario. Yeah, so a note on target definitions, we'll come back to this later. So far as I'm aware, there aren't stable unified definitions of these words at the sort of semantic level. So you can sort of talk about these things in relation to one another. One of these words maybe connotes intention, one of these words does not. But at the semantic level, there's nothing, and if there are any linguists in the audience, I'd be happy to hear from you. But so far as I'm aware, there are no indicators at the semantic level that would lead one to say, on inspection of, a claim in isolation, this is definitely misinformative, this is definitely not. So in our work, we also refrain from advancing singular definitions of these words, but sort of take each author on their word and try to make these comparisons between intended and actual targets of detection on the basis of how each author defines these terms. So following on this sort of definitional ambiguity, in the absence of these kinds of hard and fast taxonomies, what we find is that the supermajority of classifiers that we inspect, they don't actually do misinformation detection. They're not doing any form of what you would call fact checking. They detect proxies. So the most common ones we observe are emotional language, genre, topic, authorship, also virality. So what does this mean? In the absence of these like very stable definitions, you can look for these signals which on their own maybe don't connote anything, but by virtue of some external heuristic as determined by the study author, are informative. So some well-known ones, inflammatory speech or angry speech denoting misinformation, maybe really rich lexical diversity denoting reliable information. And it's trivially easy to evade these methods because as soon as you've defined the proxy, which has a sort of tenuous relationship with actual truth or falsity of information, you've also by complementarity defined precisely how to evade that detection. Okay, so if the classifier is just trying to detect inflammatory speech or very angry speech, maybe you can just like tone down like the temperature of whatever thing it is I'm writing, and maybe I've just managed to evade whatever sentiment analysis classifier I was trying to build. And some of this trickles down to the point of feature selection when developers are trying to identify what parameters their classifiers are trying to intake. So one notable example that was actually published in the security venue is this thing called troll magnifier, which detects troll-like Reddit accounts. So they start from a seed list of troll accounts that were actually manually identified, and then define a troll account essentially as any account that exhibits behavior resembling those existing like known troll accounts, which just becomes tautological because you can only find like with like, and this disallows identification of novel malicious behaviors. And as such, good data is also very scarce. I'll gloss over this because I'm already running short on time, but just know that good annotated data is scarce. Lots of old data sets are constantly being recycled for this reason. And so content-aware classifiers rarely perform well on recent or contemporaneous data. And anyone who's been working in social media research in the past few years knows that, post-Twitter API shutdown, the social media data hose has just been, it's a trickle now, and probably that's going to be gone soon too. So, this begs the question, what actually works? The things that we do have targets for are easy to evade. The things that are agnostic to content can't infer intent, and in fact are pretty easy. In fact, don't really work for proactive detection. They require some degree of virality, which makes them very useless in breaking news scenarios. The funny thing is that in practice, most detection methods on social media platforms are not like automated from beginning to end. They're actually fairly hybrid. So, the directionality of this hybridity changes depending on the use case. So I think one notable example, as I mentioned early on, was Facebook's third-party checking program, which uses automated capabilities to surface problematic content, which is then adjudicated by human moderators. These are folks affiliated with IFCN. On the other side, you have, say, if you have a human annotated corpus of images that have already been labeled, you can use automated systems to scale up that human intelligence. So an example is Facebook's SimSearchNet, which is a convolutional neural net that detects near exact duplicates of human labeled images. The thing that stands out to me, though, in both these cases is that the intelligent work begins and ends with the human. So whether that's with the actual labeling of the test data or with the final adjudication of something that's been flagged by an automated approach, the human in the loop is who's doing the work. And every time I hear that term of art, I think of this Shel Silverstein poem. There's a baby in the machine doing the homework. I don't know if the text is readable, but the machine is only as accurate as the baby is, as it turns out. So like the primary source of the intelligence remains the human. And so I would venture to say that, you can make a bunch of boilerplate recommendations about the goodness of the classifier you design. You can recommend, that weights be published, that features be made explainable, and that evaluation be ecologically valid. But at the end of the day, I think this is ultimately a labor problem. And so much comes down to how we're supporting the folks who are actually doing this work and who are making the most important decisions. And I think we should just make explicit the fact that most of these methods are hybrid. And in fact, the automated system, I think in its best positioning within this larger ecosystem is, it's a helpmeet, it's an aid to the human moderator who is actually the source of ground truth and intelligence. And I think that academic research efforts have thus far been mostly positioned towards building like the next like Mondo classifier with like a bajillion features and like a lot of compute power, but could maybe more fruitfully be directed towards understanding and defining criteria for human-machine collaboration. You know, at what point should human interventions be understood to be necessary? At what point should machine interventions be understood to be helpful? You know, that possibly is where the pitched battle should be waged, but I think is currently not the case. So what's next? Sort of shameless plug for my own research program and things that are ongoing at CITP. You heard earlier from Surya and Mahir on current work within the Digital Witness Lab. There's a different branch of that work that addresses privacy preserving analysis of encrypted messages on WhatsApp. So that's a fun applied crypto approach to the problem of grassroots governance of information ecosystems. There's also, there's been more chatter recently about alternatives to engagement-based ranking algorithms. I think Renee actually in her plenary mentioned briefly bridging algorithms, which, you know, the example that comes to mind, I think she mentioned Reddit, but the example that comes to my mind is community notes on Twitter, which promises via some sort of matrix factorization to surface annotations that are appealing to a broad swath of Twitter users. So the explainability and efficacy of those algorithms under the hood, how do they work? Do they? Who knows? More soon. Yeah, so I think that's actually all I have. The QR code, whoops, it's maybe blocked. The QR code at the top links to the preprint for the paper. So if you want to scan, that is available there. And otherwise, yeah, please email or what have you, and I would be happy to talk about this further offline.
One, two, three. Yeah, cool. All right, thank you for coming. Last talk of the day. Good afternoon. My name is Bao, a judicial law clerk at a federal court and a visiting fellow at Cornell Tech. Thank you for having me here. Just a disclaimer that this paper and views expressed are mine and my co-authors and do not reflect the views of the American judiciary. Cool. My co-author George cannot make it today, so I'll be presenting our paper, tentatively titled Audio Deepfakes and the Regulation of the Landlords of Creativity. I will briefly talk about the audio deepfakes and some of the implication of their unregulated usage. I will then briefly go over how 3 regulatory frameworks, the American, the EU, and the Chinese, try to regulate audio deepfakes and generative AI generally. I will argue that there's a liability gap in these 3 frameworks and that we should impose liability on the cheapest cost avoiders, the landlords of creativity. I will then conclude by walking through a few brief implementation examples of the proposed liability framework. So what are audio deepfakes? Audio deepfakes are like their visual counterparts. They are created by state-of-the-art AI system to mimic the auditory characteristics of an individual or an entity. As an example, I'll let AI President Obama say a few things. Let's hope that this works. As you can see, or hear rather, the results of these AI systems are so real that they could be used to mislead. Recently, a synthetic Biden robocall was played to potential voters ahead of the New Hampshire primary. The robocall used one of Biden's more well-known phrases, "What a bunch of malarkey," to try to increase voter turnout. Across the pond, an audio deepfake of the London mayor purportedly making inflammatory remarks was also uploaded online, which, according to the BBC, almost caused serious disorder. Yeah, okay. We have had many reports on malicious actors using deepfake technologies to spread propaganda, foment discord, and/or destabilize regimes. At the very beginning of the Russian invasion of Ukraine, a video deepfake of President Zelensky was uploaded online, imploring his troops to surrender. In addition to these criminal usages, voice cloning and other generative AI usage could implicate civil liability regimes such as copyright. For example, if I ask an audio deepfake generator to generate a clip of Taylor Swift singing one of her songs, that should at least, I think, implicate some sort of copyright regime. Confronted with this problem, many countries are drafting and have already enacted regulations governing the use of AI technologies. Currently, there are at least 1,600 policy initiatives aimed at regulating AI generally and generative AI specifically. In the United States, while there's a hodgepodge of statewide regulation of AI, there's currently no federal legislations. The closest we've come to a federal framework is the Biden AI Bill of Rights and the follow-up executive order on safe, secure, and trustworthy artificial intelligence. The Biden AI Bill of Rights seeks to regulate what they call, quote unquote, automated systems in order to protect the rights of the American public in the age of artificial intelligence. There are 5 principles that promote this goal. First, the user should be protected from unsafe or ineffective system. Second, they should not face discrimination by algorithms. Third, the user should be protected from abusive data practices. 4, they should know that an automated system is being used and understand how and why it contributes to the outcomes. 5th, and finally, the user should be able to opt out where appropriate and have access to a person who can quickly consider and remedy their problems. In the EU, alongside data protection laws such as the GDPR, they also recently passed the EU AI Act. The goal of this act is to regulate what they call AI systems to ensure that artificial intelligence is safe and is developed and used in compliance with fundamental rights obligation. Some of these fundamental rights obligations include the right to human dignity, respect for privacy, freedom of expression, and freedom from being discriminated against. The AI Act defined 4 different types of risk categories. First, AI system that creates what they call an unacceptable risk contravening EU values and considered to be a clear threat to fundamental rights will be banned in the EU, except in certain cases for law enforcement. For AI system classified as high-risk AI, comprehensive mandatory compliance obligations will apply. High-risk AI system will also be subjected to conformity assessment to evaluate the compliance with the Act. Furthermore, mandatory fundamental rights impact assessment and the right of citizens to, quote unquote, launch complaint about AI system and receive explanation about decisions based on high-risk AI system that impact their rights are also part of political agreement. And the third system classified by the Act is a system classified as limited risk, including chatbot, certain emotion recognition and biometric categorization system, as well as system generating deepfakes. These systems will be subjected to more minimal transparency obligations. The transparency requirements will include informing users that they are interacting with an AI system and marking synthetic audio, video, text, and image contents as artificially generated. Finally, all other AIs not falling under those 3 umbrella will be such as like AI-enabled recommender system or spam filters. They're classified as minimal or no risk. The EU AI Act allowed the free use of minimal risk AI system, and voluntary code of conduct are encouraged. Finally, the Chinese Communist Party, they have been churning out AI regulatory framework at a breakneck pace. I think they've actually done this even earlier than the EU and the American. One of the regulations is called the Provisions on the Management of Algorithmic Recommendations in Internet Information Services. This act seeks to regulate algorithmic recommendation service providers to, quote unquote, safeguard national security and the social and public interests, protect the lawful rights and interests of citizens, legal persons, and other organizations, and stimulate healthy development of internet information services. To the TBD, I still don't know what it means, but to fulfill this goal, the service provider must, among other things, establish complete management system and technical measures for algorithmic mechanism examination and verification. Now, these 3 regulatory frameworks and other regulatory frameworks vary in terms of their legality and enforcement mechanisms, but they do have a common regulatory defect with regard to the regulation of generative AI technologies like audio deepfakes. And this is perhaps because they seek to regulate general AI, not really generative AI. These frameworks do not take into account the technical reality of the current generative AI ecosystem. As you all know, it is prohibitively expensive for an average user to train base models that powers tool like ChatGPT. So I didn't do the math, but according to these articles here, GPT-3, which is now outdated, would require 355 years to train and at least $4.5 million to train. I'm not sure the average user can afford that. And so these type of computational costs could only be borne by big tech companies like Microsoft and Google. So the current generative AI landscape is dominated by a few companies with computational power enough to train foundational models, which we call landlords. These companies include OpenAI and Microsoft with 39% and 30% share of the market respectively. Unlike regular vendors, these landlords' business model revolve around a subscription-based software as a service or SaaS model, where the user, i.e. lessee, pay to use pre-trained generative AI models via the landlord's application programming interfaces, APIs. This SaaS models essentially mean that the users do not own the models, but merely lease them from the landlords. And as you can see here, all these audio deepfake generators are online services. You cannot go and download the models you use offline. So the three aforementioned frameworks do not really distinguish between the landlords of creativity and the lessees. The American frameworks, for example, lump both of them together as entities using quote-unquote automated systems that are derived from machine learning, statistics, or other data processing or artificial intelligence technique. The EU AI Act does not distinguish between the two parties either, merely seeking to regulate a natural or legal person, public authority, agency, or other body that develop an AI system, which is defined as any software that is developed with machine learning techniques. Finally, the Chinese framework imposed liability on any organizations or individuals that use generative AI. Because these landlords control everything that is needed to produce a particular output, from the copious amount of data that was used to train the foundational model to the weights of the generative AI algorithms, the landlords of creativity should thus be considered the cheapest cost avoider. Therefore, we should impose liability on these landlords of creativities. However, I also think that the landlords can shift liability to the users in certain circumstances with a simple implementation of an audit log. This audit log would, or maybe should, conform to the auditing and reporting requirements that's already baked into the American, EU, and Chinese framework. And so just an implementation example, to minimize malicious use, for example, the landlords of creativity could limit the capacities provided to unidentified and untrusted lessee. If the landlord limits the model's capacity to usage that have been extensively tested, it is possible for the landlords to potentially reduce liability if the unidentified users eventually use the models in an illicit manner. For registered users, keeping an audit trail would allow the landlord to show that whatever malicious or infringing content generated was done at the request of that user. For example, if the user provides the prompt asking the models to, I don't know, create an audio of the US president praising a religious extremist, or if they ask the models to create a song similar to the most currently listened to song, then they should primarily be responsible for the content that the landlords provided. If the prompt relates to a celebrity or well-known entity, then the landlords should at least notify the affected entity, store the sensitive content for a longer period, and warn the end users before pushing the content to the users via the APIs. Once those affected entity is notified, then potentially existing regulatory regimes, such as a DMCA takedown, would govern the subsequent actions. And if the prompt is related to a non-celebrity or unknown celebrity, then the user who requested the generation should be liable under existing law, name, image, and likeness, or privacy, if they distribute it. Once a landlord is notified of the malicious usage, however, they still are on the hook for making sure that such outputs are not reproducible. Following these implementation guidelines could either completely shift liability or at least reduce liability for these landlords. So conforming to these requirements would not be financially or technically onerous to the landlords. Many large landlords, such as OpenAI, have already agreed to identify their lessees if they are sued by third party. Additionally, it is industry practice to keep logs for debugging purposes. Our proposal should not incur a lot of technical debt, as the primary logging infrastructure should already be in place at a lot of these landlords' premises. Adopting this proposal would therefore allow the landlord space to innovate while still addressing the potential harm of such innovation. Thank you.
Thank you so much for those amazing papers.